Hello, neighbor. I'm Robert Burns, and welcome once again to another edition of Sound Off Louisiana. We are in Covington, Louisiana today, where we have just completed a 2-hour court hearing at 22nd Judicial District Court in front of Judge Burris. And boy, this was one more interesting hearing. Let me first of all introduce my three guests. We have over to my far left, Miss Rita McDonald. In the center, we have the guest you've seen many, many times, Miss Belinda Parker Brown, and her, oftentimes accompanying her husband, Carl Brown. Now, this court hearing centered on an allegation that on May the 11th of 2023, during a misdemeanor court trial hearing for a defendant, there was the allegation made that by a public defender that Miss Parker Brown had come up to him and said, you're badgering the witness, that's my client, and I don't appreciate it. This was during a recess. Let's make that clear. This was during a recess. And so when the judge returned and Mr. Richard made that statement on the record, the court said, or Judge Burris said, neither does the court. He set up a hearing today. He said in that transcript, and we're going to provide the transcript, the original transcript from that day. He said that he wanted any witnesses subpoenaed, and he would hold this hearing today, which is September the 7th at 2:30, because he was looking at charging Miss Belinda Parker Brown with constructive contempt. I don't want to give away the result because I feel like that should be something that should be allowed for Miss Belinda Parker Brown. And so with that, Miss Parker Brown, I'm going to kind of turn it over to you. I will look along with my notes as you relay what all happened today, and I'll help you out if you may have forgotten some things, because Miss Parker Brown did represent herself pro se, and I can tell you that I have done that also, and oftentimes it's very difficult to remember a lot of specifics when you have just completed a court hearing in which you were pro se. So Miss Parker Brown, why don't you go ahead and let us know just what all happened prior to and today. The floor is yours.
Yes, first of all, I would like to thank Sound Off Louisiana for being here in this courtroom today on this very, very necessary, but most importantly, hearing that was held in Judge Beers' courtroom. You know, I was brought here today to show cause. I want the people to know that, you know, I am the CEO and the co-founder of a civil constitutional human rights organization that is Louisiana United International, that is registered with the Secretary of State here in Louisiana. You know, I was asking the court to officially, in writing, approve my authority in the courtrooms of St. Tammany Parish. I was also concerned about to make a motion that they remove the indirect contempt that was a violation, right? A violation of my constitutional rights because I am a civil constitutional human rights organization.
Okay.
So I was also concerned about the fact that there could have been some ex parte communication between the public defender, which was one of my members' lawyer, that was badgering and threatening her to take a plea.
Okay.
And that was, in fact, wanting her to take a plea, and she wanted to go to trial.
Okay.
So I want to say, and that, you know, with this, people, it's so important now that we understand that lawyers cannot force people to take pleas. They cannot threaten and badger people to take pleas. You have a right to go to trial if that is your wish. And in the case of my member, I feel as though that it just really affects me. It hurts me to see them being forced to do something that they really don't understand what it's about.
Okay.
So I also want to say that the United States Supreme Court's recognized 60 years ago in the case of the National Association for the Advancement of Colored People versus Robert V. Button, January 14, 1963. The civil rights activists required that they cooperate among ordinary people and work together. You know, here, Mr. Burns, you are absolutely correct. This is St. Tammany Parish. It has been nicknamed St. Slaminy.
St. Slaminy, I've heard that
And
before.
I feel as though here in the courtroom today that there was a preconceived decision made on how they're going to ban me from the courtroom.
Now, I want you to repeat that because the judge was very clear at the end. You are permanently banned. I want to make sure that's not lost on this, and that's why I'm elevating my voice. Earlier today, when the judge rendered his ruling, the young lady that you are looking at right now, she was informed she is permanently banned from ever appearing in his courtroom again unless she is subpoenaed as a witness.
And you know, that is a very sad situation because the court belonged to the people. And as a civil constitutional human rights organization, for me to be banned from the courtroom permanently and not allowed to court watch, which I have a court watching badge. I'm also registered with the national, international press to come and be able to observe in the courtrooms, to be a watchdog in the courtrooms. And this is really sad. So I'm going to stop right there, and I want to talk to my friend Rita that is also a court watcher. How did this make you feel today, Rita, when the judge ruled that I have been permanently banned from the courtroom?
Well, I feel that judges, especially in the parish of St. Tammany, should not ban anyone from the courtroom. We have never here in the parish of St. Tammany had anything like this going on. I have told the district attorney about it. I've told several people. I really don't understand the reasoning, the understanding, the total call for the necessary abandoning of taking someone out of the courtroom.
What?
It's a free country, and if I want to be in the courtroom and sitting beside my relative, beside my friend, I should have a right to do so.
Well, and let me just chime in because I'm sure every viewer is no doubt wondering, well, what did the judge say that prompted him this? And he said that he found Miss Belinda Parker Brown to be in egregious violations of Section 4 and Section 6, and that she had interfered with the public defender's ability to represent the client. Now, the client testified that was not the case. In fact, the client said she felt much more at ease when Miss Parker Brown made it into the courtroom because, according to testimony that wasn't disputed by either the client or Miss Brown, she was feeling like she was being forced into a plea. She testified to that under oath. Be that as it may, the judge, when everything was said and done, as I just said, he said he found those two egregious violations. We should also mention he imposed, in the transcript leading up to this hearing, he had said very plainly that he could imprison her up to 6 months, and also that he could assess a fine, F-I-N-E, that he would deem appropriate given the circumstances. When he rendered his decision, he did impose a $1,000 fine, and he said Ms. Brown has 30 days in which to pay that fine, and she's also being taxed with all court costs that pertain to this hearing today. Now, I'm going to just say one or two more quick things, 'cause I don't want to take away your thunder, Ms. Parker Brown. But one of the key points to me was when Attorney Richard was up there. Now, he's the one that's making the allegation that Ms. Parker Brown interfered with his ability to represent the client. And Ms. Parker Brown asked him point blank, and she must have asked this question 3 or 4 times at a minimum. She asked him, was there a meeting convened amongst all of the public defenders in which I, meaning Belinda Parker Brown, was the subject matter of discussion, and that they were told that any involvement with her could end up being severely penalized in a courtroom. He would not answer that question. He danced all around it. And if we get a transcript, and I think you may be ordering one, that'll be easily verified. He never would answer that question. To me, that means the obvious answer is yes.
Yes, it's true.
So you pick it back up, but I wanted to make sure that was out there.
It's true, Robert, and I really appreciate you bringing that point out, because that's the reason why I feel like the fix was in here today. You know, it was an automatic trap that there was nowhere possible that I would get a fair trial here in this court. You know.
And I think you must have felt that way because, well, let's alert our viewers and subscribers of another thing. Early this morning, you filed to have this entire matter moved to federal court.
Correct.
And we're going to provide that filing as well.
Yes.
Now, that was provided as an exhibit to the judge today, and Mr. Carl is placing it up on display, and we're going to provide the direct link for it. The judge here today said, well, I don't see any order signed by a federal judge removing that, and that being the case, we're going forward. Ms. Brown then said, well, I'm supposed to have an attorney. That attorney, whose last name is also Brown, basically said, look, we weren't able to come to a satisfactory understanding on this, so I will not be representing her. Hence, Ms. Brown having to proceed pro se, which is never an easy thing. I've done it. If you've ever done it, you're going to know it's not an easy thing.
Right.
So I do want to make sure one thing is very clear. Neither the judge nor Miss Belinda Parker Brown ever used a high tone of voice. It was very soft-spoken. In fact, at times I thought, this is not Belinda Parker Brown. This is some imposter that has been brought into this courtroom, because I have never seen this side of her. So I want everyone to understand she was unbelievably polite, unbelievably professional and courteous. So was the judge. I want to make that clear. So was the judge.
Correct. Robert, I appreciate you saying that, because what's most importantly is that the judge, I think that he was more concerned about what he had been basically pulled into.
Okay.
And he was respectful. My grandmother taught me to be respectful. But, I want the people to know that, when I'm advocating on behalf of people that are being done wrong, I take it personal. It hurts me to see people being done wrong. So I want to say that, this is a part 2 to this. This is not over. And we got to take this to another level, because when it comes to people being threatened and badgered to take pleas, especially here in St. Tammany Parish, they have a right to go to trial if that's what they wish to do. And this is what was happening. And I feel like, to silence me, to basically threaten my freedom of speech, to be able to speak to one of my members in regards to what decision would be best for her to make, whether she want to exercise her right or whether she just want to go along and get it over with, to go along with this program that's here, that everybody should take a plea to get it over with. And that's not right.
Well, and this is just my personal opinion, which since this is a blog, I'm always allowed to interject it. But telling someone that, hey, you don't have to take a plea, That's not giving legal advice, in my opinion. That's something a second grader ought to be knowledgeable of. But unfortunately, some people do get intimidated, especially if you're appearing in front of a court for the first time. This is a big day. It's going to affect a lot of the rest of your life. And Miss Belinda Parker Brown was saying, that's all I was stressing to her: weigh everything, get all of the information. How will this impact your career? And I want to emphasize that the defendant, I'm using that word because there is still a matter that's pending for her, she said she felt much more at ease upon Miss Belinda Parker Brown's arrival. Now,
and you know, the attorney should have, you know, he felt like he was, you know, I'm telling you, this is not right. The attorney, if he felt like somebody was interfering with him or whatever, then he should have been a little bit more professional and just basically said, if you're not satisfied with my representation, then you are free to go and get another lawyer or whatever. But for him to go back whining and crying to the judge and making it look like, you know, he couldn't get the plea, you know, it's almost like, what is going on here? You know?
And also I want to emphasize his first action was to go to the bailiff, and who was called in as a witness. And the bailiff, when he was put on the stand, he was asked, "Did you witness this?" "No, I did not." And so you know, here's a witness supposed to help buttress the case, who the first thing he has to say is, "No, I did not witness it." Okay, what happened? Well, Attorney Richard came in and said that this had happened. By the time I got in there, Miss Parker Brown was gone. So.
Right, so the bailiff is the officer of the court, and that should have done it. It should have been all over with just that. You know, but nevertheless, you know, this is going to this level, and that's the reason why they have picked this fight with me, Robert, and I'm telling you, it's not over. We have to take it to the next level, because people cannot continue to be treated this way and railroaded into a situation where they basically manufactured a charge and a case against me. And I haven't done anything wrong except for, you know, exercise my freedom of speech and assist my members and educate them and helping them to make the best decision possible.
Well, and you go ahead, Mr. Carl.
You know, we talk to people that's in the organization, LUI, that you have a constitutional right. And we talk to people about their constitutional rights even in a courthouse. You can agree to disagree. You don't have to go with the system of what they're trying to force down your throat. So we allow ourselves to hear what they're saying, and then we go to court. We'll court watch. We'll hear what's being said, and we don't form a decision for them like Ms. Parker Brown just said. It's your decision to hear the truth and know the truth, then do the truth. If you did the crime and you know you did it, go ahead and take the plea. If there's something that sounds fishy about it, don't do it, but let that be your opinion.
It's your decision to make.
Your constitutional right is to listen to whoever is giving you what you need. And if these public defenders aren't giving you what you feel is right, then you find somebody else. And when LUI comes along the scene, we talk to people about their constitutional God-given right. And what you saw here today was the constitutional rights of LUI being trampled upon. Now, and the thing that what we've done in the federal court is we're going to show them exactly what this is all about now. Because you can't continue to, when people don't stand up for their rights, and the people that are helping you, trying to help you get your rights, when they trample against us, now the fight is on. Now there's a bigger dog in the fight. So LUI is coming at this 22nd JDC with all we got. And they're going to have to answer for what they've done.
Well, that sounds good. And I'll relay one thing very quickly. As I went to a trial in Farmerville, it's the Ronald Green matter, we had a district attorney who the judge deemed was bringing up a matter that was not the right place and time. And he did come very close. He said, "I think you know what you're about," and I mean in contempt. But he showed the restraint. But my point is, this is in an open court hearing. What happened here today, everybody stipulates to, it was during a recess. And clearly, if the bailiff was informed, the bailiff tries to go resolve the matter, unable to do so because she's gone, you know, but even if he had been there, perhaps if she is continuing to say, "Let me tell you something, blah, 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 blah," you know, sure, anybody can't can be escorted out when they're being completely disorderly. I did not hear anything in there that indicated that this was a chaotic situation, that this was some kind of protest or anything of that nature. And I thought, let me just say one other thing. Another attorney was brought in that said, well, I had interaction with her 14 years ago, and he basically said she practices law without a license. I mean, I'm just going to cut straight to the chase. And he said, I've confronted her, when did you go to the bar? His animus toward you was palpable. It was palpable.
And the judge let him go on and on with a bunch of that he say, she say, riffraff. And, what was really sad is that he's part of Walter Reed's training. Walter Reed, that our organization was very successful, along with some other great organizations, to get Walter Reed out of office because his administration here in this 22nd JDC was so egregious, so corrupt. It was just, with malicious prosecution, race-based prosecution, concocted fraudulent information, selective prosecution. That all was happening up under Walter Reed's corruption. And that's what he's part of that regime. So he got up there and he rambled, the judge let him ramble on and on with a whole lot of just, he say, she say, and, just false accusations against me because, he's worried about, his little gravy train and how they're going to continue the corruption.
Well, and again, I want to stress, now it was not him on the witness stand, it was Attorney Richard. He would not answer that question about whether or not a collective meeting of the public defenders was held in which you were the sole and exclusive topic of conversation, and it was stated, allegedly, that, look, you deal with her, there's going to be consequences. So you are obviously not just persona non grata. You now have a judge who has said you will never appear in my courtroom again.
And that tells you right there, Robert, that we're doing something right. we're doing something right. When they get that sensitive about it, we are exposing the dirt in this 22nd JDC.
There you go. Well, if y'all have any final little concluding remark you'd like to make, I'm sure our viewers can hear the thunder.
Well, Robert, I want to say this. He said that I have been banned from his courtroom.
Permanently.
So
in misdemeanor court, yeah. And I believe you're right on that. Any misdemeanor manner, you're banned.
I really want people to think about that, because when Pharaoh told Moses that...
Oh, Lord, it's kicking up.
When Pharaoh told Moses, and he spoke against Moses, he spoke it up on his own head. So just think, maybe it won't be his courtroom. Thank you.
There you go. And maybe the Lord may be sending the message down with this thunderous storm. Yep. Maybe this whole thing didn't meet with his approval. I can't speak for him, Lord knows. But I find it interesting that as we're wrapping up, we are about to have a downpour. So we will see everyone again on Sound Off Louisiana again real soon. Thank you so much.